Why do I need an attorney to look at my insurance policy, I guess is the first question.
Sure. So there are a lot of different types of insurance, first of all, and you need to make sure what you have in place, both on your personal side, but also your business side. And I'm just going to address the business side of things today, because that's what I think is most important and salient to members and business owners in Roswell these days. But your insurance policy is a contract under Georgia law. So that is extremely important to know for several different reasons. In the times of COVID and coronavirus, force majeure clauses or sort of acts of God clauses become extremely important in your contracts and whether or not they become enforceable or not. Georgia law also has an act of God defense to a contract. It's statutory. It's actually OCGA, if I recall off the top of my head, 13421. And that basically defines what an act of God is. And what's wonderful about having a statutory code section about that is that it's automatically written and implied as a implied term into all contracts that are entered into under Georgia law. So even if you don't have a force majeure clause in your contract, that statutory provision can provide sort of a saving grace. So if you're a small business, my recommendation has been to everyone to go ahead and make a claim under your policy. The reason for that is the statutory language, or I should say the case law precedent of interpreting insurance contracts is going to be, they're going to be interpreted against the insurer. And what that basically means is if there's any ambiguity in your insurance policy, the courts are going to find in favor of the insured, namely the policy holder who bought the policy, paid for the premiums, and the courts will likely enforce coverage if there's a ambiguity in the policy. What we're dealing with here in the COVID and the coronavirus, there are several different parts of the policy that are important. And there have been numerous class actions already filed across the country trying to force insurance carriers to provide coverage for claims, and they're all centering around a couple things. First is the definition of a pollutant. So under your policy, you need to look at what your definition of a pollutant is. In addition, they are looking at whether there is a civil authority provision in your policy, which would provide for potential coverage if the government authority shut down. That a lot of insurers are now relying upon to try to decline coverage is the actual physical loss language, property damage. So they define actual physical loss as something where, like, typically it would be a fire or a hailstorm or lightning strikes or something like that, where your premises are actually physically, tangibly affected. I argue, and I will be arguing, that coronavirus is a physical loss. It physically affects the property just as much as a fire would. It's just a microbial, bacterial, viral impact, but it is actually on equipment, furniture, it's in the ambient air. So therefore, it would, in my opinion, be a potential physical loss. My suggestion, even though that was very long-winded, would be, even if you don't understand what you're looking at in your policy, make a claim on your policy. And if you have the word threat of physical harm in your policy, you need to specifically cite that provision and say that we are making a claim because there's a threat of the coronavirus entering our premises. And if you're in a service industry like I am, random people are coming in the door every single day. You have no idea where they've been, who they've touched, what they've been exposed to. And therefore, it clearly provides a clear and imminent threat to yourself, your welfare, and your well-being. So
the next question is about commercial leases. All right. So I now am protecting myself with insurance. I've got a bulldog attorney like you who's going to go out and fight for every dollar I can get from my insurance company. So now I've not been able to occupy my facility because of orders, or I can't pay my rent because I can't generate any income. What's going on with the commercial lease right now?
Okay, so very similar to insurance contracts, landlords are finding themselves in the position of tenants not paying the rent and saying, hey, this COVID-19 and coronavirus has made it nearly impossible for us to function. It's frustrated our commercial purpose under the lease, and therefore we're not paying rent. That is a contractual obligation under Georgia law. No tenant is permitted to not pay rent. Unless there's something in the actual contract, the lease, that enables a tenant to abate rent or something to that effect. But generally speaking, payment of rent is absolute under Georgia law, and if you don't pay it, you can be evicted. There's a delicate balance here again in landlord-tenant law, and especially with commercial leases. A lot of landlords are saying you have to pay the rent because I've got to pay my people, my investors, my businesses, so they're losing too, and we all know this. But we're all in this together, kind of thing. And the tenants now are looking at the leases and scrutinizing them and taking the lawyers and saying, there's no way I can make these payments for at least a period of time. What can I do to avoid, getting hit with an eviction notice or a dispossessory under Georgia law? For me, hard pressed for me to argue that COVID-19 and coronavirus does not fall into the category of an act of God. So I do believe that tenants have that as a defense to payment of rent at this time. Even if there is no provision or force majeure clause in the lease contracts, there's still common law. And under Georgia law and case precedent, there are things called, as I mentioned before, frustration of purpose, impracticability, impossibility, things of this nature that basically the common law reads into contracts to forgive certain circumstances, the enforceability and performance under contracts if there are certain things like COVID-19 and the coronavirus. So I guess my two important points to take from this would be, one, if you have a force majeure clause in your contract, I would assert it as soon as possible, as that I think will protect tenants from landlords enforcing and dispossessing. If they don't have if they don't have a force majeure clause, they still can rely on the common law of acts of God, impracticability, frustration of commercial purpose, and impossibility in order to defend against a dispossessory. Advice, if you will, to both sides of the equation in the landlord-tenant situation is that the landlord and the tenant need to sit down very quickly, and they need to work through a deferment plan that makes sense to both sides, so that at least maybe some money is being paid during this time, an abated amount, and then it can be picked up at a later time. But if landlords are just going to send demands for possession and dispossessory notices, it's very likely that, in my opinion, they're going to be unsuccessful in court due to this pandemic.
So let's assume, all right, I'm a local business. I've put in my SBA. I've either gotten denied or I'm gotten a number and I'm waiting. But let's say I'm not going to get that. What else? What else can I do?
Okay, so what else can you do while you're waiting? There are two programs that are out there. There's the PPP program, and then there's the EIDL program. And I don't believe any money has come through the EIDL that I'm aware of, that I've seen out there. That was the $10,000 emergency payment that was supposed to show up within 3 days of application. To my knowledge, I haven't seen anyone get that money. But the PPP program is extremely document intensive and it's bank sensitive. My advice to you would be, if you got denied at a larger box bank, you need to go to a local bank, a small community bank, and redo your application if you were denied, and get it resubmitted through a smaller bank. With respect to the paperwork, yeah, you need to cross your T's and dot your I's. There are a lot of companies out there that just set up a company through their CPA with the Georgia Secretary of State, and they don't have their operating agreements, they don't have their bylaws, they don't have shareholder agreements, they don't have things that are absolutely necessary in order to do this. Some of them don't even have federal tax identification numbers, which is kind of critical in order to have tax returns. And usually the banks are asking for at least 2 to 3 years of tax returns. So,
if I had pending legal action before all of this went down, whether it's a transaction, I was buying something, selling something, I, was getting sued, was suing someone else, what's it look like to, be in the court system right now, or trying to get through the court system?
all right. So, with respect to this particular situation, the courts, as you know, in Georgia at least, have been shut down. It does not look like they're going to reopen for full service until at least sometime in early May. There are the clerk's offices are still open, and you can still file cases online. So lawsuits are getting filed, motions are still being filed, responses are getting filed, but hearings are all but not happening. The only hearings that are happening are critical, essential hearings that the courts and judge by judge are determining whether they merit immediate hearings. And then those hearings are being done via Zoom. So there are obviously evidentiary problems with a Zoom kind of situation because you can't say, here's my document and hold it up to the screen kind of thing. It's kind of difficult to do that. So you have to make sure that when you're filing your motions, you tender all your evidence to the court these days so that the judge has everything in front of it so you can just refer to it. But to focus on the mediation side of it, this is an ideal time to get to alternative dispute resolution mechanisms. I happen to own a mediation company, ADR Georgia, here in Roswell. Shameless plug. But the reality is that at this time where the courts are shut down and there's no indefinite solution or resolution to cases for some time to come, and what I mean by that is years of time that it's going to take to resolve cases, I would really advise folks to reconsider their various positions in their pending lawsuits and their pending disputes, and find another way to get them resolved. And mediation is an ideal situation for that.
I've over leveraged myself, and now all of a sudden the economy's tanked, right?
Mm-hmm.
So I was really, trying to grow my business, and I had borrowed money, and I was sort of, right at the hinge point. And now I find myself where I got all these bills that I can't pay. How does a lawyer play into that equation?
So that is not only from the reviewing of the contract side of it, that's a minor part of it. It's more of the connections that the lawyer can provide to the client. For instance, I happen to represent one of the largest CDCs in the country, a 504 SBA lender, and some of those rates are some of the lowest in the history of the world. They have incentivized programs now in the time of COVID and coronavirus, where if you have property involved, you can do an SBA to get out of your regular mortgage, your first or your second, or even your HELOC or whatever business line, equity line, whatever you have. An SBA loan, 504 SBA, can be used to consolidate all of that indebtedness, and you can amortize that debt over 25 years. At an exceptionally low interest rate, somewhere between 2% and 3%. So I'm always encouraging my clients, who especially small businesses, that renting, people tend to want to go and immediately rent a space. That leaves you only in the land of what are called 7A loans under the SBA. But if you want to purchase property, that puts you in the land of 504. Which for a very modest percentage down payment, you get a heck of a lot of reward over time. So from the business side of things, I said, look to refinance because if you're through a big box lender and you're out there with 5 and 6 and 7%, or you've got a variable or a balloon, then it might be well worth your time to look at an SBA 504 7A loan to refinance, because it's amortized over 25 years and it's at an exceptionally low interest rate.
what's it going to be important, what maybe wasn't in a contract before that, now it's like, we need to have, this in this contract, right?
Yeah, absolutely. No, that's actually an excellent observation, and the world has changed permanently, and it's almost inevitable that every service business or product oriented business is going to be forced to be online in some capacity. So there are three things that come to mind in my mind about this. First of all, you got a static website, passive website becomes an active website. Your terms and conditions on your website are going to be extremely critical, and that to the point where you have to have choice of law provisions on your website. If you're operating here in Georgia, even though you're shipping stuff all over the world, you want the venue and the jurisdiction to be under Georgia law because you want to be here. You don't want to be traveling to Canada. The jurisdiction issues are extremely important. So those terms and conditions on your website, especially if you're selling things on the website, are going to be extremely important to review. And that's where it really all comes down to. If you have Venmo or PayPal or some other way of paying online as well, the security measures surrounding that are extremely important. And specifically, I would definitely have disclaimers on the website and the terms and conditions, basically saying that by your use of this website, you're absolutely agreeing to the terms and conditions in every way, shape, or form. There should be limitation of liability language on the terms and conditions, so that you can't be sued for punitive damages, any consequential damages, indirect loss, things of that nature. Standard limited liability clauses that any lawyer should be able to, draft and provide for you, but that needs to be on the website. The other part of this is, now that you're serving a much broader society than sector of the society than otherwise just people coming into your shop, you have to take into consideration ADA components now on your website. If someone is visually impaired, for instance, you need to have an ADA compliant website, otherwise you can be sued under federal law because they can't access certain parts of the website. I would also say that in the disclaimer section on the terms and conditions, that you'd have a provision in there to the extent that says if you have any private information that you are exchanging through this website, that you need to notify the company beforehand of any heightened security measures that you want the company to take regarding your private information. That becomes a defense in court down the road, to where there was a condition precedent to them providing their confidential information or their private information to you. It gives protection to the company. In many,
it says use your lawyer to market your business, and if your lawyer's not marketing your business, hire a new lawyer. So how do you help your clients get more business?
Get another lawyer. That's what I always say. So lawyers are kind of in a unique situation. Everybody walks through their door. They build a client list over many, many years, and I've been doing this for decades now. And I've got a client list that's probably in the tens of thousands. And so in the back of my mind, I'm always thinking when a client walks in the door, even if it's in a litigation type of a context, I go, well, how else can I help you? What else can I do for you? Who can I connect you with that potentially can provide value to your business? Not only does that provide goodwill to the client and enables them to grow in their business, but it also, engenders trust with the client, because you know that they have their best interest in mind, and you're not just quote, the blood-sucking lawyer, as we so fondly are referred to all the time.
Is there something else that we haven't talked about that somebody should have on their radar screen?
I would put something on the door at every opening to every entry and exit to your office, basically giving notice of the coronavirus, what it is, where we are, and that you're entering at your own risk and peril, and that you basically, by use of the premises, by stepping foot inside or across that threshold, you are covenanting not to sue the owner or the landlord for anything in relation to the COVID-19 or the coronavirus.
Well, Kirk, thanks so much for taking some time this afternoon and walking through some of the legal aspects of all this. I appreciate your time.
Go ahead. This has been great. I hope that what I've said can help some folks. And if anybody has any further questions, they're feel free to reach out to me at any time. This is all about sticking together here in Roswell, and we help one another. That's what we're about.